Good afternoon, everybody. Can everyone hear me okay? Awesome. I want to welcome you all to our final Ethics Grand Rounds of fall semester. There will, of course, be another series of talks in the spring, so keep an eye out for details about that. I'm Deb DeBruin. I am the interim director of the Center for Bioethics, and I want to welcome you all here. I want to start today by acknowledging and thanking our co-sponsors for this event, the law school, the medical school, the School of Nursing, and the School of Public Health. We really appreciate their partnership in bringing this event to you. Without further ado, I'm going to introduce our speaker, Thaddeus Mason Pope. He's the director of the Health Law Institute at Mitchell Hamlin School of Law and an affiliate faculty member at the Center for Bioethics. Professor Pope uses the law both to improve medical decision-making and to protect patient rights at the end of life. He's working to balance liberty and public health, to assure adequate informed consent, and to develop fair internal dispute mechanisms, resolution mechanisms. Specific topics include medical futility, advance directives, ethics committees, brain death, and as you can see, medical aid in dying. He explores these issues in nearly 200 publications in leading medical journals, law journals, bar journals, nursing journals, bioethics journals, and book chapters. Professor Pope co-authors the definitive treatise, The Right to Die, The Law of End-of-Life Decision-Making, and he runs the Medical Futility blog, which has nearly 4 million page views. Professor Pope's engagement with health law and bioethics goes beyond academic scholarship. He bridges thought and action with amicus briefs, legislative testimony, and professional organization policy statements. He also serves on our hospital's ethics committee, and I can tell you that he is an amazingly generous colleague with his time and his expertise. So we are so pleased to have him here today. If you could join me in giving him a warm welcome.
All right, good afternoon. Am I on? Okay. Minnesota's ready for the End of Life Options Act, evolving status of medical aid in dying. I don't have any financial conflicts to disclose, but I do want to acknowledge that I have written op-eds in favor of medical aid in dying in the New York Times and in JAMA. I'm a co-author on clinical practice guidelines for medical aid in dying, published in the Journal of Palliative Medicine, and I have testified in favor of the End of Life Options Act in Minnesota in 2016. Nevertheless, this talk is going to be, it's an academic talk, so it is going to be balanced and circumspect. All right, so every year in the United States, 2,800,000 people die. 41,000 die each year in Minnesota. And many of those people want to control the timing and the manner of their death. Right, and it just powerfully, because she's sitting right up here in the back, there was really powerful testimony back in September by Bobby Jacobson and others who testified in a House hearing in the Minnesota legislature. So these 41,000 Minnesotans who die each year, who want to control the timing and manner of their death, they have 6 exit options or 6 last resort options. And we can rank these from the most accepted down to the least accepted. So this would be the list of the 6 options. If we go to the top of the list, so to the options that are most accepted, stopping life-sustaining therapy and high-dose opioids, right? These options for hastening death have been accepted since the 1970s, right? Pretty much since the time of the Quinlan case in the mid-70s, and they're well grounded in laws and practices surrounding advance directives in Minnesota, surrounding PULST in Minnesota. So if we move down the list, right, to options that aren't quite as well accepted or haven't been accepted for as long, then we might talk about palliative sedation to unconsciousness and voluntary stopping eating and drinking, or VSED. But even these really have been relatively well accepted since at least the 90s, since the time of the Nancy Cruzan case. And these options are supported by major national medical societies like the American Nurses Association, like AMDA, and others. So if we go all the way down to the bottom of the list, to the exit option that is the least accepted, voluntary active euthanasia, this isn't accepted anywhere in the United States, and pretty much nobody's even advocating for it to be legalized or accepted in the United States. So I'm not going to discuss options that are definitely accepted at the top of the list, nor options that are definitely not accepted at the bottom of the list. We're going to focus on medical aid in dying, which is kind of in the middle. And medical aid in dying, in contrast to most of these other options, is in a state of rapid flux and change right now in the United States. Generally, that's moving in one direction, which is it's generally becoming more accepted, legalized, and available in more jurisdictions in the United States. Okay, so here's the roadmap in 6 parts. First, I'm going to just describe what is MAID, or medical aid in dying, what is MAID, why do we need to legalize it, to talk about the history of legalization, and then talk about how it's been used, and then end with 2 active debates that are going on right now. And the 2 debates are, A, there's an argument that the current MAID laws in the United States are too permissive, right? They're too permissive. And the other is that they're too restrictive. Okay, so those are the 2 arguments that are going on. What I'm not going to talk about is there's a report that came out just a few weeks ago from the National Council on Disability called The Danger of Assisted Suicide Laws. So which basically raises a lot of disability rights arguments against medical aid in dying. And I'm not going to dive into all of those, but we are scheduling actually a debate over at the University of St. Thomas, which I think is going to be in mid-March. Okay, so what is MAID, right? It's an end-of-life option that's available for a small number of patients. Which patients? Who? Well, it's for adults, people who are 18 years and older, who have decisional capacity, and who are terminally ill, meaning they have a prognosis of 6 months or less. So that's who's eligible. And what can they get? What is the end-of-life option? They can ask and receive a prescription drug that they can self-administer that would hasten their own death. Traditionally, the drug has been Seconal, and they would get 90 100 milligram tablets, or 9 grams of Seconal, and you'd have to open all 90 of the capsules and kind of pour the powder out, and then you would mix the 9 grams of powder with some kind of liquid, like water or juice. Increasingly now, the physicians are using compounded drugs like DDMP, which is morphine and some other substances, instead of the Seconal, A, because of the cost of Seconal, A, because of the availability. So, this summer, the New York Times published an article with this headline, "Aid in Dying Soon Will Be Available to More Americans." And the reason they published this is because they were noting that Maine and New Jersey had just legalized medical aid in dying. And so what the New York Times acknowledged is that generally medical aid in dying has been expanding in one direction, becoming more available to more Americans. But it's worth stepping back and asking, why did Maine and New Jersey, or why does any state need to legalize and pass a statute to legalize medical aid in dying? Why do we need a statute? Well, the reason is because across the United States, since the 1800s, helping somebody else commit suicide is a crime. Former Justice Scalia noted that assisted suicide prohibitions are deeply rooted in our nation's legal history, right? And that includes Minnesota, right? So in Minnesota, Chapter 609 of Minnesota statutes is the criminal code, and inside the criminal code is this statute, 609215, which says, whoever assists in taking another's life may be sentenced to what? Up to 15 years, right? So it's a felony conviction. And then on top of that, in the Medical Practice Act, there's a similar provision which says aiding suicide is prohibited and is grounds for disciplinary action. So in addition to the criminal prohibition, there's a license, probably a license revocation or suspension. And we know that these laws are enforced because there have been relatively high-profile cases over the past few years. Minnesota versus Final Exit Network, Minnesota versus Melcher Dinkle, and then right here in Hennepin County, Minnesota versus Hauk. So the relative law enforcement officials are willing and able to enforce the assisted suicide prohibitions. So we don't have a medical aid in dying law in the state of Minnesota, but it's relatively clear that medical aid in dying would constitute assisted suicide, because if you're the physician and you write a prescription for Seconal, right, you're basically giving the patient the means by which they can commit suicide. You're physically participating and assisting in that act. So if medical aid in dying constitutes the crime of or constitutes assisted suicide, and assisted suicide is a felony, then therefore MAID is a felony. Right, so that's why we don't really have much MAID in Minnesota. Now, in 9 other states, they have statutes that authorize affirmatively MAID. These states, they all have MAID statutes. And a key thing that every MAID statute does, and sometimes they're called End-of-Life Options Act or Death with Dignity Acts, but we'll just call them MAID statutes, is they specifically say that MAID is not assisted suicide, right? Which basically takes it outside the scope of the criminal prohibition, which it otherwise would be criminally prohibited. So these are the states where we have MAID statutes in the United States. In these states, MAID is legislatively authorized, okay? But I do want to quickly tell you about 2 other states, Montana and North Carolina. So in Montana, interestingly, there is no MAID statute. Nevertheless, it's considered to be legal. And in fact, physicians like this physician, Eric Kress, do offer MAID to patients in the absence of a statute. And that's because Montana criminal law uniquely says that the consent of the victim to what otherwise would be a crime is a defense to that crime. And the Montana Supreme Court 10 years ago applied that law to MAID specifically and said, if you have the patient's consent, then MAID's not prohibited. And actually that was further confirmed this year because there was a bill to criminalize MAID in Montana, which really only made sense against a background that it was currently, the status quo is that it's legal, so we're going to make it illegal. That bill failed, but anyway, that sort of clarified that the background situation is understood to be that MAID is legal in Montana. In North Carolina, they don't even have an underlying felony statute that criminalizes assisted suicide, right? So there's no law that affirmatively authorizes MAID in North Carolina, but there's also no law that would apply to prohibit it. And therefore, there's a thought among a number of lawyers and clinicians in North Carolina that they don't need explicit authorization because it's not prohibited in any way. So there are some articles this year in the North Carolina Medical Journal saying just that. And they mocked up these headlines like this is just one example, because they did have bills in the legislature. And so the headline said, new law would permit medical aid in dying, but experts say it's already legal in North Carolina, so we don't even really need this statute. And that's the way it works in Switzerland, for example, right? Which is there's no law that says medical aid in dying is legal in Switzerland, but Switzerland is known as the worldwide medical tourism destination for medical aid in dying. So it's just understood that while it's not affirmatively authorized, it's not prohibited, and that's good enough. That said, Montana and North Carolina are definitely the exceptions. Generally in Minnesota and in most states, MAID's going to need to be legislatively authorized. So how has that worked, right? What's the history of legalizing medical aid in dying? Well, we've taken 3 paths to this in the United States. The first path, just moving chronologically, the first path has been litigation under the U.S. Constitution, right? There were some early cases back in the very early 90s with Jack Kevorkian, but things really got underway in 1994 in Washington State with this physician who basically argued that there was a right to medical aid in dying under the U.S. Constitution as a matter of substantive due process. The same argument that that justified abortion under Roe versus Wade. And he actually won before the U.S. Court of Appeals for the Ninth Circuit. And at the same time that this case was happening in Washington, there was another case happening in New York brought by this physician. He's also arguing that there's a right under the U.S. Constitution, this time under the Equal Protection Clause. He also wins before the U.S. Court of Appeals for New York, the Second Circuit. Unfortunately, both these cases, the one coming out of the Second Circuit and the one coming out of the Ninth Circuit, by 1997 were consolidated before a case before the U.S. Supreme Court. And the U.S. Supreme Court said, no, there's no federal constitutional right to medical aid in dying. So basically reversed both of the lower court cases. So that was the Supreme Court. So since 1997, generally everybody has been focusing on rights that terminally ill patients have at the state level because there's no federal constitutional right. And that's what former Justice O'Connor said in 1997, which is this matter is entrusted to what she called the laboratory of the states. So the second path, right under the U.S. Constitution did it work. The second path has been litigating under state constitutions because every state has its own constitution, and sometimes those afford more rights, broader rights than we have under the U.S. Constitution. And so there have been 15 cases brought all across the country asserting that there's a right under the state constitution to medical aid in dying. Unfortunately, all those cases have failed, and every court said there is no right under the state constitution to medical aid in dying. There's one active case now brought by this physician in Massachusetts, so we'll see what happens with that one. So, to recap, right, there's no right to medical aid in dying under the U.S. Constitution. There's no right under state constitutions. So that's why people have generally been focusing on the third pathway to legalization, which is to enact a statute. There were some real early efforts in the late 80s and early 90s to enact statutes. Those all failed, and that's because what those bills or ballot initiatives were doing was they were trying to legalize both euthanasia and medical aid in dying. And just to remind you of the difference, MAID requires self-ingestion. So the patient takes the final overt act, drinks the drugs themselves, right? In euthanasia, the clinician takes the final overt act, right, sort of with a needle or an IV. So those early ballot initiatives were actually pretty close. Nevertheless, because those failed, since the early 90s, almost all U.S. bills have only focused on MAID. Nobody's really been trying to legalize euthanasia. So things really get underway in 1994. That's when Oregon passes a ballot initiative known as the Oregon Death with Dignity Act. It has a whole bunch of safeguards. You have to make multiple requests. The patient has to make multiple requests, has to have multiple screenings. Screenings by the prescribing physician, or we might call that person the attending physician, who confirms A, that you're terminally ill, B, that you have capacity, C, that you understand what you're asking for and you understand your alternatives. The consulting physician has to confirm all the same things that the attending physician confirms. And then sometimes, if either the attending or consulting physician suspects that your judgment may be impaired, they have to refer you to yet a third physician, a mental health specialist, to confirm that you're not suffering from something that's affecting your judgment. This is one physician's a flow chart of the steps and safeguards that a patient has to straddle in order to be eligible to get medical aid in dying. I'm not going to go through this. The point is, there's a lot of steps and a lot of assessments that have to be made, and the point of them is to assure that the patient's request for this prescription drug is voluntary, it's informed, and that it's enduring. And generally the consensus is, and the evidence that's published, is that Oregon has a strong, solid patient safety record. And because of that, that model, the Oregon model, has been followed not only by other U.S. states, but by other jurisdictions in the world as well. So in the U.S., that happened first in 2008 with the state of Washington, next in 2009 with Montana, in 2013 Vermont, and these are all these statutes are basically identical to the Oregon law. In 2015 in California, in 2016 in Colorado, in 2017 in Washington, D.C., in 2018 in Hawaii. And so as of this year, the beginning of this year, we had more than 60 years of combined experience in the United States with medical aid in dying. Because if you look at how many years it had been an authorized practice in each of the states, right, you could add them up and you get 60 years of combined experience with medical aid in dying in U.S. jurisdictions. And again, the evidence that's been collected shows that a strong patient safety record with medical aid in dying. And so based on that, this year, in 2019, New Jersey and Maine also passed laws that are, again, basically identical to the Oregon Death with Dignity Act. So as of today, November 22nd, 2019, we have 10 U.S. jurisdictions that authorize medical aid in dying. Some of the advocacy organizations now say, put out this claim, which is now 1 in 5 Americans has access to medical aid in dying. And that's, I guess what I want to say just about that is that at one level, that's kind of an understatement because of this. Now, on the one hand, if you look at the math strictly, it looks right, because if you take the populations of the 10 states that have medical aid in dying and you add them up, you get to 71 million, and then look at the total U.S. population, which is 327 million, that's basically a 1 in 5 ratio. So I get where the 1 in 5 comes from. But here's what I want to point out is what I think that statistic, that ratio misses is how the residency requirement works. So all these states have a residency requirement, which means only a Colorado resident can access the Colorado End-of-Life Options Act. In California, same thing. But you may know that one of the most famous people to ever access medical aid in dying, Brittany Menard, accessed it in Oregon. She wasn't from Oregon. She never lived in Oregon. She moved there specifically to access medical aid in dying because it wasn't legal where she was at the time. So while every state says you must be a resident of fill in which of the 10 states you want, the point is that's really easy to satisfy. First of all, who confirms that you satisfy the residency requirement? It's just the attending physician, right? This is not like applying for TSA pre-check or global entry. You have to go down to the Minnesota airport and get your fingerprints and stuff, right? It's not that kind of vetting process. And then how does the attending physician confirm that you're a resident? Driver's license, voter registration, own or lease property, right? We could, in this room, in the next 10 minutes, right, we could get on Craigslist and lease property in Denver or Portland, right? Very easy. If we have the money, somebody will lease us an apartment or a house in those cities. Really easy to satisfy the leasing of property in that state and demonstrate that we're a resident. By the way, in DC, their list goes on and on and on. It goes on utility bill, library card, right? I mean, Metro card. I mean, well, okay, I'm kidding, but it goes on. It's really easy to satisfy the residency requirements. So, just to be real clear, in Minnesota, right, Minnesotans do have access to medical aid in dying because there's no reason why a Minnesotan couldn't go to a state, legal reason why a Minnesotan couldn't go to any of these other states where it's legal and satisfy the residency requirement. Now, there's no legal barrier, but there probably, of course, is a practical barrier. You do have to move to the other state. You do have to find treating physicians who are willing to write the prescription for you. Okay, so that's enough on legalization. Let me turn to usage. So like I said, we have 60 years of experience with medical aid in dying, right? Most of that, or a big fraction of that, comes from Oregon, where it's been legal for 22 years. How many people are using it, right? Well, in Oregon, in that entire time, they've had 1,459 deaths from people who ingested the prescription that they were written under the Death with Dignity Act. But it's worth noting, 1,459, in the same time period, there were 750,000 deaths in Oregon over that same period, right? So the math would show that it's only 0.2% of deaths in the state of Oregon were from medical aid in dying. right? If you extrapolate those figures to Minnesota, now Minnesota is a slightly bigger state than Oregon. Oregon has 4.1 million. Minnesota has 5.6 million citizens. But if we adjust for the larger population, per year, what would the numbers be? Well, in Oregon, in their latest report, in the 2018 report, they wrote 249 prescriptions, and 168 people ingested those prescriptions and died. That was 2018 in Oregon. So if you extrapolate those numbers for the slightly larger population in Minnesota, right, you would expect about 340 prescriptions and 229 deaths. Pretty small. Who are these people? Who's ingesting this? It's worth noting that while there are 1,459 deaths, there were 2,217 prescriptions in Oregon, because the prescriptions, which is the green line, are always higher than the number of people that actually take it. Right? People get the prescription so they have the comfort and reassurance of knowing that it's available should their suffering get to a point where they want to use that prescription. But sometimes the suffering, it doesn't get to the point, they never need the prescription. So that raises, I think, an important point, which is that there are three different populations that benefit from medical aid in dying. There's the people that actually use it, right? So their suffering actually got to a point that they found intolerable, and then they were able to take the prescription and avoid that suffering. Second, there's the people who are comforted and reassured by knowing that that the prescription is in their file, is in their medicine cabinet, or is at least at the pharmacy, and they know that should their suffering get to the point that they found intolerable, they could ingest the medication because they have it, even though they never actually use it. And then third, there's another class of people which are just comforted by, they haven't actually gotten the prescription, but they're still comforted by knowing that they could get that prescription if their suffering started to get worse. Most of the people that have used medical aid in dying in all U.S. jurisdictions and in all foreign jurisdictions have had cancer. That's overwhelmingly the main diagnosis. Most of them have been on hospice at the time, and almost all of them have been insured. That's all Oregon data, but again, you could get the Department of Health reports from any other state, and the data looks exactly the same. Okay, so what's happening in Minnesota? Well, in 2016, there was a Senate bill, and it was sponsored by Chris Eden. And like almost all bills, introduced in almost all states, it was closely modeled on the Oregon Death with Dignity Act. So her Senate bill, did get a hearing in March of 2016, but ultimately then was tabled, and it did not proceed. The following year, in 2017, there was another Senate bill, also sponsored by Chris Eden, with a number of co-sponsors in the Senate. And at the same time, there was a House bill that was sponsored by Mike Freiberg, with a number of House co-sponsors. Unfortunately, in 2017, neither the Senate nor the House bill really went anywhere. So fast forward up to this year, 2019, we again have a Senate bill and we have a House bill. The House bill did get a hearing on September 11th of this year, but again, so far, it's not moving anywhere. So looking forward, right, to 2020 and beyond, right? Generally, people think that bills in the future are going to have better political prospects for a number of reasons. One, the Minnesota Medical Association used to be opposed to medical aid in dying, but dropped its opposition, right? Back in 1991, they just followed the AMA policy, which said that physicians must not participate in medical aid in dying. But the MMA convened a task force, had a lot of listening sessions and deliberation about this, and then ultimately in May 2017 said, we're not going to oppose medical aid in dying, so long as the bill adequately safeguards patients and physicians. And then they list a bunch of things that they think are necessary safeguards, but I guess it's important to note that everything that they think is important is included and has been included in every Minnesota bill that's been introduced. So the MMA drops its opposition. Second, the track record, right, is longer than ever, right? Like I said, we now have 60 years of combined experience from a number of different states. Third, there's more public support. So there's Harris polls, Gallup polls, Pew polls, right? And so generally, these are showing that the public support is very high, right? 73%, and the other polls are all in the same ballpark. And then finally, not just more support among the public, but more support among physicians. So this is just one survey, but this is a big survey. Medscape does these surveys every year. But this was the Medscape survey showing that the physicians it was a 57 support rate among physicians, which is different than it used to be. And then finally, there's more professional associations that support medical aid in dying. I point out the Minnesota Medical Association, but it's worth noting around the country, other national and local professional societies have also dropped their opposition or support medical aid in dying. So let me turn to then what's going on right now. What are the debates that are happening right now? So like I said, we have 9 statutes in the United States, but there's a lot of ongoing efforts to legalize medical aid in dying. Right? We had bills in 20 different states this year, including Minnesota. Most of those bills in most of those states are almost identical. Right? They're all this copy and paste from the Oregon Death with Dignity Act from 1994. And that makes sense, right? Because it works. There's no credible evidence of any abuse, so why mess with what works? That said, there is a lot of criticism of the Oregon model now. And that criticism has been getting louder and louder. And that's what I want to describe for you, and then we'll finish up. And there's, like I said, there's 2 types of criticism. One is that the Oregon model is too permissive, and then the other is that it's too restrictive. So we'll do these one at a time. So in terms of being too permissive, one concern is the capacity, is the capacity of the patient. And there's 2 times where capacity matters. There's capacity of the decision-making capacity of the patient at the time of the prescription, and there's the decision-making capacity of the patient at the time that she ingests the prescription. So do these one at a time. Capacity at the time of prescription. You are not eligible for medical aid in dying anywhere in the United States if you're suffering from impaired judgment or a mental disorder, or you otherwise don't have capacity, right? It's absolutely required everywhere that this be a voluntary decision on your part. But here's the criticism. How exactly do we screen for that? Generally, the Oregon model says you only get seen by a mental health specialist if either the attending or the consulting physician thinks that you might be suffering from something that's impairing your judgment. Well, the data show that hardly ever happens. So the attending and consulting physicians participating in medical and dying almost never refer patients to a mental health specialist. So the Oregon data in the 22-year period show that the rate of referral is only 4.5% and dropping over time. And the Washington data shows the same thing. So again, I'm not making an argument here, I'm just reporting what the debates are. Many think that rate is too low. And so the argument, or at least the question, maybe it's not even an argument, but it's a question, which is, are we failing to screen out patients who are incapacitated and have impaired judgment from depression or something else? There is no proof of this. There's no proof that this is happening, but it probably does at least need to be studied. Some people, though, have already responded to at least the concern. So at the institutional level, UC San Francisco requires that every patient get the mental health screening. So California law, California End of Life Options Act, says you only need an attending and a consulting, and you only need to see the mental health specialist if either the attending or consulting thinks you need to see the mental health specialist. So the California law doesn't require it, but UCSF says, no, everybody needs to see that third clinician to get that screening. So it's an automatic screening instead of a screening by referral only. Hawaii, in the law itself, says everybody gets the third screening, gets the mental health screening. Not by referral only, everybody gets it. And it's worth noting that other places like Belgium, at least for people who don't have a terminal illness and at least for mature minors, they need to get the mental health specialist screening. And then some of the newer laws that have been proposed, for example, in Scotland, also require an automatic mental health screening. So there's a current that maybe we should build that in straight up as a requirement. Okay, so that's capacity at the time of the prescription. What about capacity at the time of ingestion, right? So when you're drinking this, the drug, generally there's no clinician present, right? You're doing this at home with your family, and there's not normally a clinician present, which means there's no capacity assessment at the time of ingestion, right? So does the patient have capacity at the time that she ingests the drug? Who knows, right? We don't know this. It's not being measured. It's not being assessed. So again, what's the response? Well, here's one response. Do what Canada does, right? Which is have direct clinician administration instead of self-ingestion, because then you would have a clinician assess capacity at the time of administration. So that's what now happens in Canada. So they assess capacity at not only at the time of the request, but at the time of administration. That's also what happens in the Benelux countries. Okay, so that's two ways in which MAID laws are argued to be too permissive, and maybe we need to have additional oversight, additional scrutiny. There's a lot more arguments that MAID is too protective or too restrictive, and therefore unduly restricts access of patients to MAID. And these break up into two categories. People focus on the eligibility criteria, and they focus on the actual the safeguards in the process. So in terms of the eligibility criteria, who can access MAID, right? Again, you have to be an adult, you have to be terminally ill, and you have to have decision-making capacity to request the prescription for yourself. Okay, so what are the arguments for why this is too restrictive? One, on the adult requirement, right? That normally means 18 plus. It's worth noting that some states, like Maryland's bill, was going to raise that up to 21. Now, the idea of requiring that it be an adult makes sense, right? We want to assure that this is voluntary and informed, and by limiting it to adults, it helps assure that these people can make a competent decision. But the argument goes, well, we allow minors to make other healthcare decisions, including life and death, life-sustaining treatment decisions. So in many states, we have a mature minor rule where we allow children under the age of 18 to make life and death treatment decisions. So what's happening? Well, we already allow pediatric MAID in the Benelux countries, and Canada is considering that right now. And in fact, when he was reelected a few weeks ago, Prime Minister Trudeau said, yeah, I will support exploring that. So the second way in which current MAID is argued to be too restrictive is the terminal illness requirement, right? The way that's used in the United States right now in every jurisdiction is it means you have to have the physician prognosticate that your death is likely within 6 months. Again, that makes sense. That's the Medicare hospice eligibility criteria, so it's a well-settled rule for terminal illness. But the argument is that's pretty temporally strict, right? And so people may have unbearable suffering, even though they're not within a 6-month prognosis. And in fact, the argument is stronger because these people are going to have unbearable suffering for even longer period. So the argument is actually stronger that they should have access more than the person who's within 6 months. And it's worth noting that one of our largest national professional medical associations, the American College of Physicians, which absolutely is opposed to MAID, by the way, nevertheless points out this is completely arbitrary discrimination to limit it to people with a 6-month prognosis. That's a weird and arbitrary line to draw. And so what we see across the world, for example, one of the most recent jurisdictions to legalize medical aid in dying, Victoria in Australia, the Prime Minister, by the way, we have other places also have leaders tweet stuff out. This is the Prime Minister of Victoria, or the Premier of Victoria, right? He's describing the law that they had just passed as the most conservative voluntary assisted dying model in the world, right? And they're very proud of it. We have the most conservative MAID law in the world. Nevertheless, even they extend it from 6 months up to 12 months, at least for neurodegenerative illnesses, right? So they're not actually the most conservative in the world because we don't go to 12 months in any U.S. jurisdiction. So the response is what? Well, one is there have been bills to extend from 6 at least up to 12 months. Oregon considered a bill just this year to do that. It didn't pass. But the other pathway that you see getting increasing traction is just to drop the time requirement altogether. That's what we have in the Benelux countries, and that's what we now have in Canada. Canada only requires that death be reasonably predictable, which has now been interpreted due to some recent litigation as pretty broad. So there's no temporal requirement at all. You just have to have unbearable suffering, and death needs to be foreseeable, but it doesn't have to be within any specific time frame. So another argument for why current MAID law is too restrictive, right? The capacity requirement. So in every U.S. jurisdiction, when you make that request for the drug, that you have to make that request on your behalf, right? You can't be, somebody else can't ask for it for you, and it can't be in an advance directive. But, and here's the main argument, is what about dementia? Well, the problem with dementia, and here's somebody in late stage dementia, is by the time you're terminally ill with dementia, you're not going to have capacity anymore. And when you still have capacity with dementia, you're not terminally ill. So you cannot satisfy two of the eligibility conditions at the same time. What's the response? Allow advance, again, I'm not advocating this, I'm just saying these are the debates that are happening. Allow advance requests for MAID, right? So you could say, when I get to this point, that's when I want you to administer well, of course, it's not going to be self-ingested. It's going to be physician-administered. This is what's happening already in the Benelux countries, and there was a recent case where it was challenged because when the physician came to administer the euthanasia, the patient was kind of resisting, and then there was a question about whether that constituted a retraction or revocation of the prior instruction, and the court ruled no, because she's completely incapacitated, so her resistance didn't reflect her true, authentic will. It was an incapacitated gesture. It didn't count. Canada is now considering whether or not to allow advance requests for MAID. So to recap, there's a push to expand the eligibility criteria from adults to at least mature minors, to move it from a 6-month prognosis to 12 months, or perhaps to remove the temporal requirement altogether, and then to move the requirement from the patient, a capacitated patient making a request on her own behalf, to allowing the patient to make a request in advance for the future. So that's the eligibility side of it. On the procedures and the safeguards, there's a push to streamline those as well, to expand access. So one is there's a 15-day waiting period. So you have to make the request, but then 15 days later you have to make the request again to make sure that it's a settled, true, and authentic wish on your part. Hawaii actually went a little higher and it made it a 20-day waiting period. But again, the idea is to assure that this is an enduring, settled, deliberated, reflected upon request on your part. But the argument is that waiting period constitutes an undue burden on a number of patients. And the data reflect this. During the 15-day process, more than a third of patients lose capacity. So by the time they have to make the second request, they can't make the second request with capacity, or they die during the 15-day period. So majority of patients can't survive the 15-day process. Either they're not alive, or they can't, their capacity doesn't survive. So the response, as an example, again with Victoria, is to waive the waiting period, at least for those patients who are expected to die within the 15-day waiting period. We're not going to make you wait 15 days because you can't wait 15 days. And it's worth noting, Oregon did pass a bill this year that does the same thing. So Oregon now waives the 15-day waiting period for patients who, in the physician's judgment, can't wait the 15 days. And then a lot of the newer bills that you see being proposed in the legislatures also are taking out those or at least relaxing those waiting periods. The second requirement that's perceived to be a little bit restrictive and is unduly restricting access is the self-ingestion requirement, right? So the way MAID works in the United States now is the physician prescribes and the patient at a later point in time ingests on their own or with their family. And again, self-ingestion was thought to help assure that it's voluntary on the patient's part. Nobody's doing it to her, she's doing it to herself. But two problems with this. One is a lot of patients lose the ability to self-ingest. So one is there's people who can't drink. Now there are generally in most of the MAID states right now, there are alternative mechanisms of administration. So if you have a feeding tube, as long as you can press the plunger, right, you the patient are still taking the final overt act, right? So you're causing the drug to go into to be administered. And there's even anal administration if they can't take it by mouth. But at the end of the day, whether it's by feeding tube, mouth, or anal, it's still all gastrointestinal, and that is a problem because there's a relatively high complication rate. So if you look at the Oregon published data from the Department of Health, they're putting out basically a 7% complication rate in terms of regurgitation, seizures, and other complications. And therefore, what's the response that's recommended? Well, in Victoria, again, it's normally supposed to be self-administration, as in U.S. jurisdictions, but physician administration is allowed in those cases where the patient is physically incapable of self-administration. So we don't allow that in the United States. If you can't self-administer in the United States, you can't access MAID. So there's no exception in the United States. And then the other pathway that's recommended is the Canadian approach, which is clinician administration, right? So in Canada, according to the latest data, in the last 3 years, there have been 6,749 MAID deaths in Canada. Only 6 of those were self-administered, right? So 6,743 of the total were all clinician administered. And the one thing you get with direct clinician administration through an IV is there's no complication rate. And that's also the way it works in the Benelux countries. Okay, so then third, the other thing in the United States is the attending and consulting physician, right? They have to confirm that you're terminally ill. They have to confirm that you have capacity. That has to be a physician, an MD or DO. And we all know, right, that there aren't enough and there's a shortage of physicians. So that creates access problems, especially in rural areas. So what's the response? Extend it to NPs, right? And it's worth noting for context, in Minnesota, as in most states that have POLST, physician order, provider orders for life-sustaining treatment, NPs can sign those orders, right? So we already allow NPs to participate in similar sorts of things. In Canada, 4 to 7% of MAID deaths have been by NPs, not by physicians. And you see, even in some US jurisdictions, some of the newer bills, like in New Mexico and even New York, when they authorize medical aid in dying, it would be extended to NPs as well. The NPs could be the attending or the consulting physician.
Also Minnesota.
Oh, and Minnesota. Thank you. Thank you, Eileen. So to recap, right? So we have these legal barriers, whether some people call them safeguards, but I guess the point is that some people are saying the safeguards are in fact barriers, both in terms of the eligibility criteria and in terms of the process requirements. So some people say we need to relax it, we need to loosen it up. Other people say we need to tighten it up in some ways. And I guess it's worth noting, and I'll finish, that there are, on top of the legal barriers, there are some practical barriers. The drugs are often very expensive, and people have difficulty affording the drugs. People have difficulty finding, even in a state where it's legal, they have difficulty finding a physician who's willing to participate. They need to find 2, of course. They need an attending and a consultant. They need to find 2 physicians, sometimes 3 physicians willing to participate. And now, increasingly, we have another challenge, which is conscience-based objection, right? It's always been the case, including in all the bills in the United States, that nobody has to participate, right? If you're a hospital, you don't have to participate. If you're an individual clinician, you don't have to participate. Nobody's making you participate in MAID. And it's worth noting that almost no religiously affiliated hospital participates in MAID, and most academic teaching hospitals do participate in MAID. But the point is, nobody's making anybody participate if you don't want to participate. But let's say you're a clinician and you work with a Catholic for a religiously affiliated system. The general rule has been, and the state laws specifically permit this, that if you're doing it on your own time, outside the purview of your job at the hospital or with the health system, that's okay. But now there's some new litigation in Colorado where, with this system, this Catholic affiliated system, fired this physician because she wanted to help this patient. And that's a new development, because so they're arguing that even though that's prohibited by the Colorado End of Life Options Act, the Colorado End of Life Options Act specifically says if a physician wants to participate in medical and dying on her own time, that the system where she's an employee or a member of the staff cannot retaliate against her. So what they did, and they fired her, is absolutely prohibited by the Colorado End of Life Options Act, but the Centura is arguing that they have a First Amendment right under the U.S. Constitution to fire her, and we're going to see where that goes. So let me just wrap up. So in Minnesota, we have 41,000 people are going to die this year. For 99% of them, MAID is completely irrelevant, right? So that means of the 41,000, 40,800 MAID is not relevant at all. But many of them also want to already do make a deliberate decision to hasten their death, right? A lot of people who have end-stage renal disease make a decision to stop dialysis, even though they're not getting an organ transplant. People turn off, right next door, right? They turn off mechanical ventilators. They stop clinically assisted nutrition hydration, and a lot of other things, and make decisions to hasten their death. There's a principle of constitutional law and a principle of ethics called equal protection, which is that people who are similarly situated should be treated alike, right? Every day, terminally ill patients in Minnesota hasten their death by withholding or withdrawing life-sustaining treatment that could have kept them alive longer. Probably, and I did this math on the back of an envelope, but probably every 30 minutes somewhere in the state of Minnesota. Some patients don't have anything to turn off. There's nothing to refuse. They're not dependent upon any form of technology, post-1950s technology. So MAID gives these terminally ill, competent adults the same freedom that the others do to control the timing and the manner of their death. Thank you.
So I'm going to ask for questions that you just indicate that you have one clearly enough that I can tell, because I'm in a crowd like this, I always miss people, and then use the mic. So this is where I get my steps in today.
My question is basically about the refusal of food and liquids. And I don't know what your experience has been with the challenges to that. One of the issues that has come up repeatedly has been the workers in the individual hospital or convalescent or wherever they are, and that they're uncomfortable with it. And that has become, at least in some areas, a significant barrier.
So we're not talking about MAID anymore. Now we're talking about VSED, right? Yep. So another path, and the argument is you don't need any affirmative legislation in Minnesota to authorize VSED because patients in Minnesota already have the right to refuse. If you don't want something, generally nobody has the right to force it upon you. So one way to hasten your death is to stop eating and drinking, and you'll dehydrate, and you'll be dead in 10 to 14 days from dehydration. And the medical evidence shows that leads to a relatively peaceful and comfortable death. But you're right. Long-term care facilities aren't, well, there's two concerns. A, they're not personally comfortable with it. They don't want to participate in it. And then second, they're not completely sure that they're allowed to do it. Yeah, so that absolutely is a challenge, and I think we need to clarify the legality of VSED as an exit pathway. But that's something to consider when you're for your family, when you're placing you in some kind of long-term care facility, is to pick a facility that is willing. If you're planning to VSED, that you would pick a facility that would be comfortable and willing to honor that choice.
Thank you for your presentation today. Very informative. Just a comment and a question. First, you talked about your polling. I think it was misleading. You're correct that many people, when they're asked, do you want an end-of-life option, like you're suggesting, do say yes. But polling also shows pretty unequivocally that when you go into the details of the bill, support for PAS precipitously drops. I think you're also maybe not entirely accurate about the exemption for faith-based providers. House File 2152 in the new bill, different than the last one, has a provision which expressly would prohibit a provider that's employed by a faith-based institution from opting out of the PAS protocol. And then finally, a question for you. You were introduced as a champion of adequate informed consent. What is your feeling about line 4.26 in House File 2152 that would affirm lip reading and communication through persons familiar with a terminally ill adult's manner of communicating as acceptable? This would be change over one oral request and written request being required. So no longer is a written request required to trigger the process. It can be obtained at any time in the process. There's only a recommended form of consent, which does not even require witnesses.
Yeah. So two things. What that bill doesn't do is it doesn't address exactly how some requests are definitely going to be made. So there's an interaction here of federal law and state law, and so as an example, people who are not native English, so English as a second language, and also people who have a disability and they can't communicate. There are already federal regulations that require that you have certified interpreters or translators, right? So I think basically that rule would be preempted by the federal rules on how you communicate with somebody who can't speak English or with somebody who has a disability. So I think the federal rules would trump that provision in any case.
I was curious if in the jurisdictions that currently allow MAID, if anyone has used an advance directive or that style document to kind of use that for the capacity concerns where they are directing their future treatment, and if that hasn't happened, if that would be a feasible legal way to do that in the future.
I'm sorry, use an advance directive to do what?
So you can use an advance directive to say, in this state, I don't want further care, or like withhold these things. Couldn't that same document be used to say, I know I have a cancer, it might not be terminal yet, or I might not have the 6-month provision yet, but in this state, I want to be able to use MAID as a way for my treatment?
Well, you could definitely write that in your advance directive, but it wouldn't be honored, and it wouldn't be authorized by the law, right? So the attending and the consulting need to talk to you and assess your capacity at the time, both at the first request and then 15 days later at the second request. And the advance directives only become applicable, they're springing, they only become applicable when you lose capacity. So you could write it in your advance directive, but it's unenforceable.
But why couldn't then your advanced POA person then say, yes, this was their wish?
They could say it again, but the law specifically says the request has to come from the person herself contemporaneously. Right. You could do all that. You could write an advance directive. Your POA can go and talk to the oncologist, but nobody's writing the prescription on the fact scenario that you just painted in the United States. In Netherlands, you can do that, but not here.
Hi. Thank you for your support in this very important topic. My question is, do you have any statistics on how many people with a terminal illness or expect to have a disease that they know will be devastating that commit suicide? My grandfather, who we watched dehydrate to death before he was unable to communicate, kept saying, just let me fall down the stairs. Of course, we didn't let him. But what what do we know about people who choose suicide early on rather than being able to, because they don't have an option like this?
That's a great question. I don't have the data. I mean, but we do know that there's a fair number of suicides, and there's a fair number of assisted suicides. Which and this is actually a big debate, because the American Society of Suicidology would say that when you're ending your life in the face of a terminal illness, or at least a serious illness, that's not suicide, because you're already dying, right? You're only controlling the specific timing and manner of their death, but you're already dying. And so then they would say that wouldn't be a suicide. And I don't think, though, that the figures that we collect on U.S. suicides disaggregate the data in a way that we would have a really good figure. But we know we know that what you just said is happening.
I have a question that kind of weighs on my mind, is that, a lot of costs are incurred by insurance companies at the end of life, and I just worry that there will be pressure to save money and cut costs to choose this rather than providing alternative coverage for people at the end of life.
Right.
And you'd hate to have anybody forced into this.
Absolutely. So, I mean, it's worth noting first that the average age of somebody who uses MAID in any of the states that have it is higher than 65, which means their primary coverage is Medicare. And Medicare, there's no federal dollars can be spent for MAID. So just for the first thing to say, I guess, just a matter of what's happening right now, MAID is actually the more expensive option. Medicaid doesn't do cost-benefit analysis. Medicare will basically pay for anything, right? And so MAID is actually the more expensive option, not the less expensive option from the individual's perspective. And current federal law absolutely prohibits federal dollars to be spent for MAID.
Thank you for your presentation, Thad. I understand religious opposition to MAID, but I have a question about the state's opposition, and it's shifting. Clearly, we can tell by the spread of the jurisdictions. But in the history of suicide, states have had different attitudes towards suicide. For example, if the state needed workers, they tended to be opposed to suicide. But if they needed workers, if they didn't need them, they weren't. And I was just wondering if you had any insights into contemporary state opposition to suicide and what that might be about.
Well, I'm going to confess that I've never heard that the state, when they didn't need work, that's an anthropological or sociological point that I'm not familiar with. I'm sorry. That when the state doesn't need workers, then they're okay with suicide?
It has been in the past.
Okay.
It has been in the past, at least in the history in France.
Oh, okay. I wasn't familiar with that fact. So I'm not sure if I can intelligently comment. Sorry. That's super interesting, though.
As a hospice social worker, I see how we can add quality of life and comfort to people's lives. How much education is a prescribing or consulting MD? How much education do they have about the hospice benefit, and going that way first to see if that can't be a solution?
Well, yes. So they have to. When you make sure that it's an informed choice on the patient's part, you definitely have to tell them about their other options. And palliative and hospice care is absolutely at the top of that list. And it is worth noting that almost everybody who ever got MAID in any U.S. jurisdiction was already on hospice. So it wasn't like they're doing it instead of hospice, they're doing it while they're on hospice.
I have two questions. What is the definition of terminal? And then second, what is the moral argument that you're hearing from the religious community?
So, terminal right now means 6 months. That's the well-settled definition. It's ingrained in the Medicare conditions of participation. It's in all the MAID statutes. So you can't get MAID until you're terminal, and that means that there's a prognostication that your death will come within 6 months. The religious, so here's the thing. No, again, normally you don't have to participate, right? So if you have a moral objection to MAID, you don't have to participate in MAID. But let's say your patient asked you, right? This is actually, there's some litigation happening right now in New Jersey, this is just the most recent iteration of this. Your patient asks you, but you have a moral objection, a conscience-based objection to MAID. You do have a legal duty to transfer the patient's records to another physician, because the patient's like, well, if you're not going to write the prescription for me, I'm going to find a doctor who will. Then your duty is to transfer the patient's records to the new doctor. One argument, and this is what's happening in the New Jersey case, and this was also the same argument that happened in a Vermont case a few years ago, is that makes me complicit. Because even, I'm not the one writing the prescription, but by transferring the records to somebody who will write the prescription, I'm facilitating in a moral act. I'm complicit in a sin. And that's a key thing, is they don't want to have to participate even to that small extent. And that's what's happening. That's what's happening in New Jersey. The Colorado case is they're saying we don't want anybody on our staff or any of our employees to participate in MAID, even if they're doing it on their own time, because that affects the culture of the overall organization.
I have a two sort of pronged question here. My first is, what sort of coverage does this legislation provide to pharmacists who may dispense this medication? And then you said that more prescriptions were written than are used. I was wondering if you know any data about how many of those prescriptions are filled, and if there's any recommendations about what to do with those lethal medications that are unused then in our communities.
Yeah, so that's a great question. So just to take the last part, I mean, the general rule is, we already hospice medication. Those are not the same drugs, but they're also obviously very, very powerful drugs, morphine and so forth. So whatever the rules are that we use to collect unused hospice medications we should also use those rules to collect unused MAID medications. But you're right, that's not perfect right now, and that system for collecting isn't perfect. What was the other? Oh, so the
Coverage for pharmacists.
What do you mean by coverage? Coverage.
Just like legally, because pharmacists could be fired or sued for medication.
No, so as long as everybody is following, so every End-of-Life Options Act in all 9 statutes absolutely says that if everybody's following the rules that are outlined in the End-of-Life Options Act, you have immunity. So you absolutely gives you criminal immunity, civil immunity, and immunity from the pharmacy licensing board. So that's as long as you're following the rules in the statute.
Thank you for your presentation. Have there been any efforts to rescind the statutes that about assisted suicide?
Efforts to rescind.
Yeah.
So that's never happened, right? So every year there's an additional statute, but we've never gone backwards and had a state that used to have medical aid in dying that no longer has it. So that's never happened. There are definitely efforts. There's the New Jersey litigation. There's litigation in California right now that are aiming to challenge the legitimacy of the statutes.
No, I'm thinking of the ones that make assisted suicide a felony that are existing in statutes still.
So there's two sets of statutes, just to be real clear. There's sort of old laws from maybe 1890, which basically say assisted suicide is a crime. Right? They weren't about medical aid in dying, but they would encompass and include medical aid in dying. Nobody was thinking about medical aid in dying in 1890. Then there is another class of statutes, which only, I think, have been enacted in maybe 6 or 7 states, which specifically say that medical aid in dying, when a physician writes a prescription of a lethal substance for a patient, that's a felony. So there's only a few states that specifically criminalize medical aid in dying. That list has been growing. Definitely, like Ohio, Utah. So those states have been growing over the past few years, specifically targeting medical aid in dying. Nobody's amended the statute, those criminal statutes. The way you amend those criminal statutes is when you authorize a MAID statute, that a provision inside of the MAID statute undoes the criminal prohibition. So the Minnesota bill that this gentleman was referencing, there's a section in there, I don't remember the number, but there's a section in there which says this doesn't fall within the scope of the criminal prohibition of assisted suicide in Minnesota. That would still be a crime in Minnesota, right? So if you took your husband and put him in the garage and turned on the car, that's still assisted suicide, and it would be assisted suicide even if we legalized the End of Life Options Act. So does that make sense?
Right,
so we
but I'm
keep
saying
the criminal
get rid of
prohibition,
that
we just
statute.
carve out the MAID conduct.
What I'm saying is let's rescind that statute that
Oh.
just clears it all up in Minnesota.
No, but we don't want to rescind that statute because there's still going to be nefarious, people like somebody shooting somebody else in the woods, somebody smothering somebody with a pillow. We still want to criminalize that. We only want to carve out clinically supervised, carefully vetted processes.
I think we've got time for one or two more questions. Anybody want to make me run upstairs? Let me come around.
The guy.
Thanks for your talk. I was just wondering, are there any ongoing studies about the mix of medications that are given or the route of administration? Because that 7% complication rate just seems like worst case scenario for a lot of patients. And I'm just wondering if there's any ongoing work looking at how to optimize that.
Yeah, there's a big, yes. So the problem is, I think there's a couple problems. Because of the secobarbital cost, people started moving to compounded drugs. Unfortunately, there's not as much of a track record with those compounded drugs. Secondly, there's still, most states use the word ingestion instead of self-administration. And ingestion is generally understood to refer to and I think that's the problem. Some states allow administration, which means it could be an IV, right? So you could set up the IV as long as, again, the patient takes the final overt act. So that would be allowed in those states, and I think that would avoid the complication rate. There's this is actually going to be the big topic. There's a big conference. It's the first time we had it in the United States. February 14th and 15th in Berkeley. It's called the NCC MAID, National Clinician Conference on Medical Aid in Dying, which isn't going to talk about these policy issues or ethical issues that I'm talking about. It's going to talk about those clinical patient safety issues, and it's for clinicians. And so that's a major focus of that conference in February.
All right. Last. I'll run. You can start. And
given that we're in an ethics situation here, do you think there's an ethical issue about access to care, given that some people will be unable to afford some of the extra measures you mentioned about getting this treatment by establishing residency in other states, for example? Do you understand my question?
So go ahead. I mean, there's an inequitable access.
Yeah.
Some people have the resources. They can move. They could go to Switzerland. They can go to Colorado, and other people can't.
Is that an ethical issue or a legal issue or both?
Yeah, it absolutely is an ethical issue. We have the same ethical issue with organ transplantation access, right? People with resources can list themselves at a transplant center where the waiting list is shorter, right? Like Steve Jobs, California resident. Where did he get his liver? Tennessee, right? Most people don't have a private plane where they can get eligible to be listed with a transplant center placed thousands of miles from their home. So this absolutely, it's an inequitable access problem based on socioeconomic resources. That's true.
so for those of you who couldn't hear, that was Professor Weber saying that's one of the reasons why you might have bills allowed nurse practitioners, because it makes it easier for people to access care. I want to ask you to help me in thanking Professor Pope.